In 2000, one more constitutional amendment was introduced and passed by the name of 81st Amendment, and a new clause was inserted, clause 4B. And this clause provides for reservation in respect of unfilled vacancies which were reserved in an earlier year, how those unfilled vacancies are to be treated in the subsequent year. This clause provides that the reserved unfilled vacancies of a previous year will be treated as a separate class of vacancies in subsequent years. Since there is a provision of reservations under clause 4 and 4A, and certain seats are reserved in favor of backward class of citizens or in favor of SCs and STs, if those seats or posts which were reserved for those classes, and if they could not be filled up in that particular year, then those vacancies will be carried forward to subsequent year, to the next year, and in the next year this carried forward vacancy group will be treated as a separate class of vacancies. That is what this clause provides. Let us see the language. This article does not prevent the state from considering any reserved unfilled vacancies of a year as a separate class of vacancies for subsequent years. Again, this is an enabling provision, so to say, but it allows the state, it permits the state in considering the brought forward vacancies from a previous year as a separate class of vacancies in the subsequent years. And the major thrust of this amendment is that these brought forward vacancies from earlier year will not be considered for determining the 50% ceiling for reservation in the subsequent year. Which means in any given year, the total reservation under 4A can be more than 50%. 50% is the ceiling for one particular year in respect of vacancies of that year. If there are brought forward vacancies from an earlier year, those vacancies will be added up but as a separate class, and if we consider the total reservation in a given year, it can be more than 50% because of that reason. Now both these clauses 4A and 4B were challenged before the Supreme Court, and they were considered in M. Nagaraj versus Union of India. A very important judgment was delivered in 2006. Let us see what were the important points laid down in that judgment. First of all, the court declared that the constitutional amendments by which Articles 16, 4A and 4B have been inserted flow from Article 16.4. So these two clauses flow from clause 4 only, and therefore they do not alter the structure of clause 4. Since they do not alter the structure of clause 4, and clause 4 was very much there in the original constitution, therefore the insertion of 4A and 4B does not alter the basic structure of the constitution. The main reason for upholding the validity of these amendments was that in both clauses 4A and 4B, the controlling factors or the compelling reasons were retained. The controlling and compelling factors in clause 4 were three: backwardness, inadequacy, and efficiency. And the same have been retained in 4A and 4B also. These two clauses do not obliterate any of the constitutional requirements, namely ceiling limit of 50%, which can be termed as a quantitative limitation, the concept of creamy layer, which can be termed as qualitative exclusion, and subclassification between OBCs on one hand and SCs and STs on the other hand. The state concerned will have to show in each case existence of the compelling reasons. Now this is the requirement. Whenever a reservation is to be provided, then the state which proposes to provide that reservation will have to demonstrate existence of three compelling reasons. Firstly, backwardness. The class in respect of which the reservation is being provided should be a backward class. Inadequacy of representation. The class in favor of which the reservation is being proposed should not have adequate representation. There should be inadequacy of representation as far as that class is concerned. And lastly, and very importantly, the overall administrative efficiency should not suffer on account of reservation. Now, where from is this requirement coming? Overall administrative efficiency. We have seen clause 4. We have seen clause 4a also. There, what is being talked about is backwardness of the class and inadequacy of representation. This third requirement of overall administrative efficiency has no mention in clause 4 or in clause 4a. So where from is this requirement coming? This requirement is coming from Article 335. Article 335 lays down that whenever claims of SCs and STs are being considered, then these claims should be consistent with efficiency of administration, which means that efficiency of administration should not be adversely affected whenever special claims of SCs and STs are being considered. And from there, this requirement has been taken by the Supreme Court, and it is because of this requirement that the ceiling of 50% has been laid down. In court's opinion, if reservation exceeds 50%, then overall administrative efficiency will suffer. To maintain administrative efficiency, the reservation should be limited to 50%. The impugned provision is an enabling provision. The state is not bound to make reservation for SCs and STs in matters of promotions. Clause 4a is only an enabling provision. It enables the state to make the reservation if it so wants. So, in every case where the state wants to exercise this discretion in favor of reservation, then there is an important requirement. The state which wants to provide reservation must have or must collect quantifiable data showing backwardness of the class in favor of which it seeks to provide reservation. So the first requirement is that it should have quantifiable data to show backwardness of the class concerned. Secondly, it should also have quantifiable data to show inadequacy of representation of that class in public employment. And of course, Article 335's requirement must also be complied with. That is, efficiency of administration must not suffer. Even if the state has compelling reasons, the state will have to see that its reservation provision does not lead to excessiveness so as to breach the ceiling of 50%. And as I mentioned earlier, the ceiling of 50% is coming from the requirement of Article 335. And the reservation provision should not obliterate the creamy layer or extend the reservation indefinitely. Now, these directions were given in 2006 in the case of M. Nagaraj versus Union of India. However, these directions were modified by the Supreme Court in 2018 in Jarnail Singh versus Lakshmi Narayan Gupta. And the modification is also quite important. Let's see what that modification is. The court made three important observations. Firstly, the 2006 directions on collecting quantifiable data on backwardness of SCs and STs was contrary to the 1992 judgment by a 9-judge bench. The reference here is to the judgment by a 9-judge bench in the case of Indira Sahni versus Union of India, which we have just now discussed, that 1992 judgment. And the court now observes that the directions in M. Nagaraj's case regarding collection of quantifiable data to show backwardness of SCs and STs was contrary to the directions of the 1992 judgment. And the court declares that the states are not required to collect quantifiable data reflecting the backwardness among these communities. There is no requirement now onwards to collect quantifiable data to demonstrate the backwardness of the communities. The court declares that SCs and STs were the most backward or the weakest of the weaker sections of society, and these classes are presumed to be backward. So the state need not demonstrate their backwardness. The state need not show their backwardness. The state need not collect any data to prove that they are backward. The court says we presume them to be backward, and therefore as far as SCs and STs are concerned, there is no need to collect any data. Reservations in matters of initial appointment as well as in matters of promotions can be straight away provided to these two classes. This is what the import of the judgment in the case of Jarnail Singh versus Lakshminarayan Gupta is. A completely new concept was introduced by the 103rd Amendment Act of 2019 by inserting a new clause 6 to Article 16. This clause provides for reservation for economically weaker sections of citizens in matters of public employment. Clause 6 says that this article does not prevent the state from making reservation of appointments in favor of economically weaker sections of citizens other than classes mentioned in clause 4, in addition to existing reservation and subject to a maximum of 10% of posts in each category. The language of this clause is similar to the language of clause 4. Like clause 4, this clause is also an enabling provision. This clause permits the state to make special provisions in the matter of appointments to public employment in favor of economically weaker sections of citizens. This clause does not apply to those classes which are mentioned in clause 4. We are aware that what is mentioned in clause 4 is the backward class of citizens. Therefore, those backward classes of citizens which are covered by clause 4 are excluded from the provisions of clause 6. It applies to the remaining economically weaker sections of citizens. It should also be noted that this provision relates only to appointments, that is the initial appointments. It does not extend to promotions. Just as clause 4 provides for initial appointments, this clause also provides reservations in matters of initial appointments. As far as the extent of reservation is concerned, the Supreme Court has already laid down a ceiling of 50% in respect of reservations under clause 4. This clause makes it very clear that a maximum of 10% of posts can be reserved in favor of economically weaker sections of citizens, and this quota of 10% will be over and above the ceiling of 50% which has been already laid down by the Supreme Court. So, total reservations in initial appointments in public employments can now go up to 60%. What is meant by economically weaker sections of citizens? That term is defined here, unlike the backward class of citizens, which was not defined. The explanation says that the economically weaker sections will be such as may be notified by the state. So it has been left to the discretion of the state. The criterion for deciding whether a given section is economically weaker or not will be based on family income, and there may be other economic disadvantage indicators as well. Thus, the Constitution 103rd Amendment Act 2019 enables reservation in public appointments to economically weaker sections of citizens other than those classes of citizens which are already covered by clause 4, that is the backward classes of citizens including the SCs and STs. So reservation under clause 6 is not available to SCs, it's not available to STs, it is also not available to other backward classes of citizens covered by clause 4.